And NBC News legal analyst and former federal prosecutor Kendall Coffee.
I think as devastating as a lot of this information might seem to be in the court of public opinion, most of it is not going to be allowed in a court of law. Where self-defense is claimed, as in this case, if the alleged shooting victim, Trayvon Martin, has a reputation for violence, that would be something that witnesses could come in on the stand and talk about. But the other things, the texts, the photographs, that had nothing to do with George Zimmerman's state of mind. He'd never seen this young man before, and it would be so poisonous on the jury's state of mind that I think the judge is likely to keep it out.
Is there precedence for this, Kendall?
Well, there's a number of cases. Well, let me jump in and then Wendy, if that's fair, because Florida has pretty clearly laid out the rules in this kind of area. If the shooter, in this case Zimmerman, knew about prior things of Trayvon Martin, that could probably be talked about because, again, it would affect his state of mind at the time of the shooting. But apart from what Zimmerman actually knew, it's going to come down to a reputation for violence in terms of Florida. And I think the state is going to be able to show that there are not people in Trayvon Martin's community that believed he had a reputation for acting violently.
You know, here's something else, Kendall. There's all sorts of laws out there that are protecting juveniles. We don't necessarily get their names to be released in the public. What about teenager privacy of those text messages and things like that? I mean, Trayvon Martin was a teenager when he was killed.
He was a teenager, and normally that kind of privacy would apply. But where the stakes are this high, a second-degree murder case, if the defense can establish its relevancy, and Wendy was talking about some very technical differences in different state laws, it's certainly not going to be the easy thing for the judge to make decisions on this. But if the defense can establish the relevancy, as we're hearing the word probative value, the ability to prove things, then I think the right of a fair trial, like it or not, is going to trump a teenager's privacy rights in terms of what the jury may consider.
Now, what happened in April when Zimmerman waived his right to a pre-trial stand-your-ground immunity hearing? I mean, can the defense invoke this during the trial?
Well, that's a fascinating question. Haven't seen it done before in Florida. And the key thing is going to be whether or not George Zimmerman is guilty, whether he can create a reasonable doubt as to his self-defense argument. That's still going to be decided by a jury. But I think what the defense is attempting somewhat creatively to establish is that, look, if the jury acquits George Zimmerman, can't the judge, based on that same evidence, determine that George Zimmerman, again, if acquitted by a jury, is entitled to stand-your-ground immunity? That has a lot of other implications, including it would eliminate the risk of a civil lawsuit if the judge were to impose stand-your-ground immunity.